In a civil lawsuit in New York, when you bring a case involving medical malpractice or an accident matter or even a wrongful death matter, and your case goes all the way to trial, can you sit with your attorney at counsel table as if you are another attorney and sit and make all of your observations and notes at counsel table? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. There's really no prohibition about that I'm familiar with that prevents a client from sitting at counsel table in one of these civil cases in New York. However, the custom and practice is that now, in a civil case, the client typically will not sit with the attorney. And there's an interesting reason for that. And it has to do more, I think, with strategy and the perception of what's going on. The perception is that now the jury is sitting and watching your attorney, the plaintiff's attorney, go ahead and prosecute your case. Many times, regardless of the size of his or her law firm, the attorney prefers to be sitting there by himself at counsel table. Now, why is that? Because oftentimes, when you bring a lawsuit, there are multiple defense lawyers who are involved with representing the interests of the different people or organizations or companies that you have sued. So there might be 3 or 4 or even more defense lawyers who now represent the interests of the people whom you have sued. So now when you go up to trial, and now you have your attorney sitting there all by himself, sitting at counsel table, and the jury looks over at the defense table and they see 3, 4, or 5 lawyers. What does that look like? It looks like they're all ganging up on your attorney. He's just one guy, regardless of whether he comes from a law firm that has 100 attorneys or 2 attorneys or just 1. Most of these defense lawyers come from firms that have many attorneys. And the jury may not recognize that, but there is a definite perception that when they see one attorney going up against 3, 4, 5 attorneys, there is an interesting play. There's a play and a perception there that says, hey, these lawyers look like they're ready to gang up on this poor single solo attorney. If you sit by counsel table, now the perception changes a bit. Now it's 2 on 3 or 2 on 4, 2 on 5. And still, there's a perception that your attorney is now getting some additional help, that now it may change the dynamics of how the jury sees this case. Now, substantively, meaning the issues in the case and the facts of this case don't change, but the perception clearly changes. And that's why many times I believe an attorney will prefer to have their client sitting in the back of the courtroom observing until, of course, they have to go ahead and testify, at which point they will be in the witness box and the jury will be listening to everything they have to say. But until then, sitting in the back of the courtroom, in my opinion, is a much better strategy. At the beginning of the trial, when the attorney makes opening remarks, the attorney will introduce his client to the jury. He will introduce the people involved in this case, and the jury will see the client sitting in the back, and they will understand that this is the injured patient, this is the injured victim, and now they will see that person there every single day, and they will recognize, okay, this is the injured plaintiff. If they were to sit up at counsel table, now it looks like they are trying to assist their attorney or that their attorney needs help in going ahead and prosecuting this case, and that's not really the perception that most attorneys want to portray. Now, you might be thinking, what happens if it's just one-on-one, one plaintiff's attorney against one defense attorney? Well, even then, if now you add your client, the injured patient, to the counsel table, now you've got 2 people prosecuting this case, your attorney and you sitting at the counsel table, the plaintiff's table, and you've got only one little attorney sitting on the defense side. Now maybe it looks like you guys are beating up on the defense, and you don't want to give that perception. So I think it's an important point that a lot of injured patients don't realize has a subtle effect on what happens in the courtroom. Does it have a dramatic effect? I don't think so. I think it's more subtle. But many times, injured patients, injured victims think, hey, I see it in criminal cases all the time where the person who is accused of these crimes is sitting with their attorney at the defense table. And that is true. However, that doesn't happen really in civil cases. Sometimes The client wants to sit up there, and now the attorney will have to ask the court for permission for the client to sit up there. And that's not really done very often. So why do I share this quick information with you? I share it with you because this is something, it's an observation, that when you walk into a courtroom in any court in New York, you're going to see this in a civil case and wonder, why isn't the injured patient, why isn't the injured victim sitting with their attorney? And in my opinion, this represents an accurate answer about why the attorney does not have the client sitting with them. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, you know what I'm going to tell you, right? Pick up the phone and call me. I can answer your questions. This is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.